application in the matter of Epping Forest District Council and Somani Hotels and others.
Morning, Mr. Coppell.
Lady. I appear with my learned junior, Ms. Natasha Peter for Epping Forest District Council. Ms. Wigley, King's Counsel, and Mr. Riley Smith appear for Somani Hotels. Mr. Strawn, King's Counsel, and Ms. Elliott appear for the Secretary of State of the First Intervenor. And Mr. Butler appears for Clear Spring Ready Homes, the Second Intervenor. My Lord and my Lady, we have 4 grounds of appeal for which we seek permission to appeal from this court. I shall make an introductory and then deal with the first 2 grounds of appeal. Ms. Peter will deal with the 3rd and 4th grounds of appeal. The introductory point is this. Quite apart from each of the 4 grounds having a real prospect of success, there are 2 compelling reasons for this appeal to be heard by this court. And for those 2 reasons alone, we say that permission to appeal should be granted. The first of the 2 reasons is a planning reason. In seeking permission to appeal, the District Council does so in its capacity as a local planning authority. And over the last 12 months or so, the turning over of hotels that had previously been open to and used by the public for all the facilities that they offer to instead being used exclusively for the placement of asylum seekers has become a matter of public concern. That it has been done without any planning consideration has served to accentuate that public concern and make it into a matter of planning concern. And it is a matter of public and planning concern that, of course, goes wider than just the Bell Hotel episode. And what we say is that, on the face of it, to turn over a building that had previously been open to and used by the public when, in this case, visiting Epping, to dine and to hold functions, and to be used instead exclusively for the placement of asylum seekers, is not to continue its use as a hotel.
The point is, Mr. Coppell, that your appeal has nothing to do with whether it was a breach of planning permission or not. Your appeal is about whether the judge was right or wrong in the exercise of his judicial discretion to refuse injunctive relief. So I can't at the moment follow the argument that by giving permission to appeal, this court, when it came to deal with the appeal, would be dealing with the matters of concern that you have flagged.
Well, Lady, the reason is because the 2 matters cannot be disassociated. You cannot disassociate what we say was the breach of planning control and the gravity of the breach of planning control and the ramifications of the breach of planning control from the exercise of the discretion to grant or to refuse an injunction. They do not sit...
That sounds like your ground 1.
It is ground 1. They don't sit in silos. They're not... The discretion is not decided in splendid isolation.
There are 2 aspects on there. One is breach of planning control, and then the other is, well, assuming there is a breach, would you get permission, for example, if this were to be dealt with through the appeal process? But that second question will be highly fact-specific and policy-specific, according to the circumstances of each individual case. And you wouldn't expect this court to be saying anything about that.
Not this court, but it might say something about the court below in its disinclination, more than disinclination.
Yeah, but if we're looking to analyse what is the compelling point really about, it's about the material change of use argument.
Yes, it is, and that is a broader matter of considerable public concern, and the court will be aware of that. And it's a matter of planning concern.
There are 2 things that strike me on that. One is that the Court of Appeal in Westminster has said already that it's a fine distinction between the 2 uses. again, it'll be highly fact-specific. So I'm wondering what the Court of Appeal can actually say usefully beyond what's been said already, both in the Court of Appeal and in the High Court, about the factors which may be relevant.
Well, standing back and looking at this point, as a preliminary point, is it supposes that the grounds themselves, we'll deal with those later.
Yeah.
Is it a matter of other concern which provides a compelling reason
Well, the problem I have with that, Mr. Coppell, and forgive me for putting it in this blunt fashion, is if ground one has a real prospect of success, you don't need a compelling reason. If it doesn't, then your compelling reason falls away because the very basis for your compelling reason is that the judge should have grappled with the issue, and if we don't think that's arguable, then there's no compelling reason.
Well, with respect, my lady, it isn't put like that for the purposes of compelling reason. We stand back further and look at the conspectus of the issue here. And when it comes to what might be called non-legal grounds, the other compelling reason, one does it in a more public-facing fashion. One asks oneself, given the concern that...
The public concern across the country.
Exactly.
Yeah, but that was the second thing I was going to ask about, because in that context then, it's all the more surprising, but so far as I'm aware, maybe wrong, there isn't an instance of a local planning authority taking enforcement action up and down the country, despite all the injunction hearings that happened a couple of years ago.
Well, it may be described as surprising. One of the reasons I would suggest for that is that if one goes down the conventional enforcement route, then of course there's a potential of many months before anything can be done about it, such that the injunction route, which is specifically provided to be in addition to any other enforcement vehicles that may be there, has the immediacy which answers the immediate problem, which is...
But the time which has elapsed since this became an issue and was a matter of public concern, there's been plenty of time to have enforcement notice appeals.
But as regards the Bell Hotel, that's not quite right. And when we look at...
I'm dealing with your other compelling... I appreciate you say something different in relation to this case.
Well, I can't speak...
I don't think it's the moment, speaking for myself, that your compelling reason point is
well,
necessarily...
Your strongest.
That's the... it's not going to improve by reiteration, I venture to suggest.
Anyway,
So
we have the point.
You have the
we
point.
have the point,
That's
Mr.
the
Coppell.
first.
We understand that there is, you say, public and planning concern across the country, and that in itself should, if you like, tip the balance in favour of granting permission so that the whole thing can be aired in full.
Yes, and also so that we can get what I would call an update on the House of Lords position 23 years ago. House of Lords decision, which I might add, was very much coloured by Article 8 and the fact that one was dealing with the impact on that, in relation to the discretion. So that's that. Second compelling reason relates to the third and fourth grounds, and they go to the costs order in favour of an intervenor. The court will be aware that there has been an increasingly liberal approach taken to the joinder of persons as intervenors in proceedings, including in non-judicial review proceedings, in private law proceedings. And indeed, that was the subject of observation by this court in its judgment in late August last year. What hasn't been the subject of corresponding consideration are the costs orders in favour of the intervenors, and in particular making sure that the increased preparedness of the court to add others as parties to proceedings doesn't result in increased litigation uncertainty. What I mean by that is that the cost exposure of person A when it institutes proceedings against person B is of course something that every properly advised person will take into account before instituting those proceedings. for A to be exposed to the costs of unknown and indeed unknowable number of other individuals, we say adds material uncertainty to an already sufficiently uncertain process.
But it depends, doesn't it, on who the intervener is and whether you could reasonably anticipate that they'll be allowed to intervene. And it may well be that if they apply to intervene and they have a proper basis for a legitimate part to play in the process, one of the parties can say, well, we remain neutral on the question of whether you allow them to intervene, but court, don't let them in unless they do it on a cost-neutral basis. And we've seen that done in this court time and time again with interveners, and indeed in the administrative court or the planning court. But ultimately, once somebody has intervened and it hasn't been done on that basis, then it's a matter of judicial discretion, isn't it?
My lady, it is a matter of judicial discretion, but and that's the very point that's being made here, is that there needs to be clear guidance on the exercise of that judicial discretion. Sometimes, as your lady has observed, one can predict that a certain other person may wish to join as an intervener, what might be called a known unknown.
Yeah.
But there will be some times when that is completely unknown, and the present case is an instance of that, albeit they haven't sought their costs. Epping Forest could never reasonably have known that Clear Springs Ready Homes Limited would wish to intervene and be permitted to intervene in these proceedings.
Well, can I ask a question? You were seeking the injunction. Say it was granted. Say that the Home Office had notice of the injunction, and indeed the other parties who were providing the accommodation. If they carried on, for the sake of argument, putting asylum seekers in the hotel, could they have been pursued for contempt of court?
Only if it related to this particular...
Yes, of course. That's built into my question.
Yes, but that is Somani hotels. That is not Clear Springs.
But I asked about the Home Office. If they had continued to instruct people to provide services to them by way of finding accommodation, which included this hotel,
Sure.
and they knew about the injunction, would that have been in breach of the injunction potentially?
Potentially.
Yes. So it would seem they would have rather an interest in the matter.
Yes, my lord. I don't have any...
I mean, the object of the injunction was to stop them relying on the hotel.
Correct. That's not the issue here. The issue here is really, because that is what I would have characterised...
Yes, but I'm going back to your submission about foreseeability. I mean, foreseeability might cover those who would have an interest in defending the injunction.
Correct. And that's...
Lest they be in breach of it in the future.
That's at one end of the spectrum. We don't have any difficulty with that. But at the other end of the spectrum are the unknown unknowns.
Well, then you have to cater for that in a case in which it arises. I mean, I can't see that it's a legitimate function of this court to start trying to lay down guidelines for judicial discretion without having some sort of factual basis on which to provide the guidance, because, and I'm not sure that this court would ever be drawn into doing so. On the facts of this case, you've got known knowns, I think, in terms of who's likely to have intervened for the reasons that my lord has given. And then the question is, when they apply to intervene, am I going to ask that they bear their own costs? Or am I going to get their agreement that they bear their own costs? And if they don't agree to it, am I going to ask the court that they should bear their own costs as a price of getting involved? And if I don't do that, well, then I'm going to have to argue against having to pay their costs on the basis that it's all jolly unfair, because I didn't predict that that would be something I had to buy into in the first place.
Lady, I've agreed, my lord, that the first intervener was a known unknown, but the second intervener was an unknown unknown, and I think that's a fair analysis. There could be any
But
number.
you didn't have to pay their costs.
No, we didn't have to pay their costs because they didn't apply for their costs. That's happenstance. So But the point is this, that for the purposes of a party instigating litigation at the inception of the proceedings,
Your point is there's a risk.
there is a risk,
Yes.
and they are entitled to know have some guidelines of that risk.
Yeah.
We've been given guidelines by the court in terms of intervention, that's fine, but correspondingly there needs to be some guidelines from this court, as there were in relation to joinder, about the cost ramifications. That's the second preliminary point.
Are you going to come back to your South Bucks argument and saying that we need some guidance
Yes.
for non-Article 8 cases?
Yes, I am.
Okay,
Hold your
I'll
fire.
wait.
Um,
I wouldn't call it fire.
So that brings me to the first ground of appeal, which is what we say was a failure on the part of the judge below to determine a necessary and central question. Your ladyship and lordship will be well familiar with section 187B, and we say that the first question that falls to be answered in any application for an injunction under that provision is there an actual or apprehended breach of planning control? Section 171A defines what is meant by, quote, breach of planning control for the purposes of the Act. Absent an actual or apprehended breach of planning control, there is no power to grant an injunction under section 187B. And the importance of answering that first question goes more than merely getting through the gateway to an injunction, because the answer to that first question involves identifying what is the breach of planning control and the gravity of that breach. And it's only through answering those questions that the consequences of that breach can properly be determined.
If I say to myself there is a material change of use, changing residential to offices, that's sufficient to define the breach of planning control.
Well, in a binary sense, yes, because that is necessarily a breach of
Defining
planning.
the breach of planning control doesn't require the decision maker, as I understand it, to go further to say how serious a breach of planning control one's talking about. That instead is the second question: what are the consequences?
If you don't mind my answering it this way, yes and no,
Because to understand which is which.
yeah, because particularly in relation to something such as a breach of planning control, it isn't. Ultimately, it has to be resolved as a binary question, but there's obviously a spectrum in terms of that.
In getting to the answer.
Well, it's got to be a material breach.
Yeah.
It's got to be more than de minimis, yes.
Yeah, so there needs to be, in a reasoned decision, an articulation of what it is that makes it a material breach. And in doing that, that is going to inform the second question, once you get through the gateway, the materiality of the breach itself.
But what is wrong with a judge faced with this making an assumption in favour of the party seeking the injunction that there is, for the sake of argument, a material breach of planning control, looking at what is said to be, on the factual evidence before the court, the consequence of that alleged breach, and then exercising judicial discretion on that basis, because you're no worse off as the claimant if an assumption is made judicially in your favour.
If that were all that there was to it, yes, but that is not all that there is to it, because when we put to the judge below what was the breach of planning control and its materiality, we had a whole host of matters that we said went to materiality, and you have to look at the totality of them. The reason I answered yes and no is it's if and only if the judge says, I accept every single one of those in terms of making the assumption that there has been a breach of planning control, in which case, when it comes to the exercise of the discretion, you would expect the same to apply to the...
Well, that's what I was going to ask you about. You're saying you need to know what factors went into deciding whether the change was material, not as an end in itself, but because it informs the discretionary exercise as to what are the consequences of
Correct.
this. So the real question, perhaps, is, well, did the judge or a judge fail to take into account one of those matters? And I appreciate you have attacked the way in which he did handle certain matters, but I'm not sure any of your grounds have said that actually it's this planning factor which he failed to address altogether.
Well, the way I've put it, you'll see in one of the what might be called the sub-grounds in ground 2, is that he gave paramountcy to the asylum ground and then considered in a secondary fashion one or two other,
Absolutely.
such as criminality and
He downgraded, I think you say,
Yeah.
one or two matters. But my question is, taking that on the chin, as it were, was there something which he failed to deal with altogether?
in terms of
Which went into the material change
Materiality.
of use.
Well,
Yeah,
what we say
I'm
is
trying to keep up with you.
we say it's impossible to discern from his reasons whether all of the matters that we put to him resulted in a material change of use, were accepted by him or not accepted by him. And so, if I
Well,
could,
in those circumstances, don't you have to assume that they were? Because if he's making an assumption in your favour, then he must be also making that assumption on the basis of everything that you've said.
well, that's rather difficult, my lady, to reconcile with his reasons, because if I just take your ladyship and lordship to the skeleton that was before him, so that's in the supplemental bundle.
Yes.
Tab 6, starting at page 46, 46.
Yeah.
And
Sorry, could you give me the page again?
yes, it starts at page 46.
Sorry, thank you.
And you'll see, if you just look at the table of contents, a whole section on principles, blah, 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 etc. And then application is dealt with starting at page 37. And question 1 is what we call the quartering of asylum seekers at Bell Hotel use as a hotel. And then secondly is the material.
Is that para 109?
That is,
It-
yes,
you-
paragraph
Because you're
109.
in internal pagination 37.
Yes, there is. If you look in the centre.
Yeah, I've got it. Thank you.
So that's starting at paragraph 108.
Yeah.
Yes.
And what we do in paragraph 109 is identify what it is in this use of the Bell Hotel that we say deviates from use as a hotel as ordinarily understood. A whole series of factors. Now, that goes directly to materiality.
Of the change of use.
Yes. And so we identify those in paragraph 109 and 110, and we sum it up and we say it's the coming and goings of heterogeneous patrons staying for different periods, for different purposes, mingling with businesses and those living in the community of contribution.
But forgive me, I understand there were these factors. These are threshold questions. They are determinative of whether or not there is a material change of use, which determines whether planning control applies at all.
Correct.
And so that's what the material change of use test is doing. Do I need planning permission? If you do need planning permission, then you go to the planning merits. Coming back to the question I was trying to put to you, the question surely is, which of those factors in 109 were planning consequences which needed to be taken into account in the exercise of discretion as to whether to grant the injunction?
We say all of them.
Well,
we say,
What,
because
the fact that somebody couldn't book a room in a hotel is a planning consequence?
Well,
Yes,
in some of the cases where the hotel was important to in Great Yarmouth, the tourism industry, it's on the seafront.
Yeah.
But you would see that point deployed under the planning merits part of the argument.
Well,
And you would see it in a ground of challenge. The judge didn't take into account the policy in the local plan to protect our tourism industry. But that's why, to cut through this, with respect, I'm asking the question, where do you actually say there was a factor that he failed to take into account altogether, as opposed to getting it wrong?
well, that's moving really to ground 2, in
Yeah.
one facet of ground 2, because as we say,
Absolutely.
he put at the top of the pile, is the way I put it, the 1999 Act and then considered one or two other matters. And apart from that, was silent. And what we say is that's an inversion of the way it should have been done in the exercise of his discretion to grant or refuse an injunction in the planning regime. What he should have done is look at all the planning considerations, see where they go, and then, of course, take into account, we're not saying he shouldn't take into account at all, the 1999 duty on the Secretary of State in that way. But what we are saying is it's not the outcome in itself, it's the methodology of decision making when it came to the exercise of the discretion. But I've jumped ahead of myself because at this point we say that he had to decide this matter, and it's not simply because of the injunction itself, it's also because of the other relief which Epping Forest sought in this case. The claim form expressly sought two forms of relief. The first, of course, was the injunction under 187B, and the second was a declaration that the current use of the Bell Hotel didn't amount to use as a hotel. And we made our position perfectly clear, A, in the claim form, and B, in our skeleton argument before the judge. And had the judge answered the first question for injunction purposes, he would have had to have decided whether turning over the Bell Hotel to asylum seekers amounted to use as a hotel. And had he done so, and had he found that it didn't amount to use as a hotel, he may have refused the injunction for any number of reasons. But on the face of it, Epping Forest would have been entitled to a declaration to that end.
It needed a declaration. If it was said openly in a judgment, then the declaration wouldn't add anything to the mix.
But he didn't, my lady, that's the point.
I know, but it's a way of complaining that you didn't get relief that you might not have been entitled to, even if you did what you said, even if you did what you said you should have done.
That is what was prayed for in the claim form. And if a party prays for relief, and a particular form of relief, in this case declaratory relief, the declaratory relief can be regarded as a lesser step than the injunction, because all that it was asking was, did this amount to use as a hotel? And that would have facilitated other matters, other enforcement matters. That was the point of the declaration.
Well, that's really what I wanted to ask you about. One of the cases, Messier Doughty, in the bundle of authorities, says it's a discretionary matter, obviously.
Sure.
Says that one consideration is whether the grant of a declaration would serve a useful purpose. Would you accept that that's a relevant consideration?
Yes.
Yeah. So, hypothetically, assume you have a case where a judge has decided not to grant the injunction, but there's a parallel claim for a declaration about whether a material change of use has taken place, therefore a breach of planning control. What useful purpose would it serve for the court to grant a formal declaration where it's refused the injunction?
Because at that point they could insist on the person making the use of the hotel to put in an application for planning permission, because there had been a material change of use.
Who could insist?
The local planning authority,
Oh,
my client.
I thought you meant the court for a moment.
The planning authority.
The planning
could
authority.
insist
The local planning authority.
that-
That is a useful for Epping's purposes.
But
given
there's no legal mechanism by which they can insist on that.
no, there is no legal mechanism. But if
I mean, all they
You'd
can
have to
do
serve
is
a
an
notice
enforcement
saying
notice.
yes.
That's how the statutory scheme works.
yes, they could put an enforcement notice, but at that point, one of the first questions for the enforcement notice and its enforceability will have been answered.
Well, that's this is what I was thinking about. If it comes then before assuming an appeal, a planning inspector, several months later, they will look at the material change of use issue for themselves at the time, in the circumstances then prevailing, which may be the same as when they were being considered by the Court of Appeal or a judge,
High Court.
or may not.
Yes. So in that situation, if the circumstances have not changed, it would be a it this way, a brave planning inspector who, after a trial in which this issue was resolved by a High Court judge, came to a different conclusion. If, on the other hand, there'd been change of circumstances, then it becomes easier and easier, of course, for the planning inspector.
Yeah, but because of the possibility of change of circumstances, which of course is an unknown, then it calls into question whether there's utility in granting the declaration in the first place, as opposed to leaving the normal statutory process to be worked through.
Relating that to the facts of this case, the issue here is the exclusive use of the Bell Hotel for the placement of asylum seekers. It's difficult to see, other than possibly some of the hotel being used for that purpose and other parts of the hotel being used for its conventional purposes. It's difficult to see what material change there could be from the facts as they were presented before Mr. Justice Mould and as they would be presented before a planning inspector.
So basically you're saying it's a useful shortcut to going through the otherwise laborious process of enforcement notice.
Yes, my lady. So if we fail to get our injunction, we get a lesser prize, is the way that I put it. But it's a worthwhile prize from our perspective, bearing in mind the sorts of issues that were being thrown up by the planning consultant and Somani itself.
So it's a discretionary exercise. Usefulness is a factor, but you're making the submission on the facts of this case as they then were before the High Court.
Yes, necessarily.
Necessary.
Otherwise.
Well, I wasn't sure whether you were suggesting that a judge should do it more generally.
Well, I'm
Because, I
happy
mean,
with
one of
facts
the
this
changes in
case.
circumstance you could have, maybe not this case given its location, is not necessarily a change on the site itself, but in the character of the surrounding area.
Certainly. But that
This
isn't the case
material
here.
change of use has to take that into account as well. So, and of course, we bear in mind a High Court judge doesn't have a site visit.
Doesn't necessarily have a site
So
visit.
it'd be rather unusual.
It would. But the material was all there. Ultimately, my lord, what you're driving at is how practical is the reality of Section 187B and what it requires, and indeed the
But
ability...
it's an adjunct, isn't it? That's why Lord Kharma's recommended its introduction, that it was going to provide an extra tool in the armoury available to a local authority.
And bearing in mind that it was always possible for a local planning authority to get an injunction under Section 222 of the Local Government Act. So one asks oneself, well, why is it that this provision...
Well, the test in 222 is a bit different.
It is.
Expedient in the interest of the local... I forget the words, but... you can see why 187B is very useful if you've got a building about to be demolished, for example, an irretrievable change in the state of affairs, or some very serious environmental damage which is about to take place.
Well, one bears in mind, of course, that there are stop notices and temporary stop notices also in the armoury of a local planning authority.
No cross undertaking as to damages, though, with an injunction. No compensation liability.
Yes, although to get an yes, I take the point. If I can move on around,
Thank you.
unless there's anything further from my. So the second.
Mr. Copper, we're distracting you from your task.
That's
Just
your
pipe down
job,
a
my
little
lady
and
and my
let you get on with it.
The second ground comprises of what might be described as a miscellany of what we call misunderstandings and misapplication of principles.
Yes.
But the upshot of which is that even if a handful of them are made out, we can't be confident that the outcome of the just and convenient exercise would have been the same. So we're now in the discretionary territory. And learned friends in their various skeleton arguments are keen on reminding the court and this side that the discretion to grant an injunction is a fact-sensitive exercise. So it is. But the consequence of it being a fact-sensitive exercise is that if you get the facts wrong, or leave out facts from an account, the fact sensitivity means that the outcome ceases to be reliable. So it's a two-edged sword. So there are a number of subgrounds here, and the first of these, which is called subground A, is that in relying as the judge did in the exercise of his discretion on Epping Forest's, what he described as a serious procedural error in not having planning evidence before bringing the claim. He confused the date of Epping Forest's decision to progress the claim, which was the 5th of August last year, with its decision to bring the claim, which was the 11th of August. And in that period...
Sorry, to confuse the decision to, what was it, how you describe
to
it?
progress the claim.
That was the 5th.
That's the 5th. But the actual decision to bring the claim was 6 days later on the 11th of August. And what was important is the welter of material, including planning evidence, that Epping Forest mustered in that intervening period. And you'll see the description of the judge at paragraph 199 of his judgment. And that conclusion, this serious procedural error, was on the basis, as he understood it, that the decision to initiate the proceedings was concluded on the 5th of August rather than the 11th of August. Now, before getting to this, let me dispel an argument variously raised by the other parties, that this is an argument of recent invention by Mr. Coppell after the trial itself. And we see that in Somani's skeleton argument, the point is made, paragraphs 41 to 50, and in the Secretary of State's skeleton, paragraph 7. The reality is that Epping Forest's position before the judge was fairly and squarely that the deliberative process followed by Epping Forest in deciding to seek an injunction involved all the planning evidence that Epping Forest had mustered in the week after the 5th of August up to the 11th of August. And that is in plain writing in the council's opening skeleton before the judge below. Your ladyship and lordship would go to the supplementary bundle. It starts at it's at tab 6, starting at page 46, but the relevant passage is at bundle page 89, internal page 42. And it starts paragraph 125 at the foot of page 89 onto paragraph 126 over the page, where we state in terms the deliberative process followed by Epping Forest in deciding to seek an injunction under section 187B is set out in various witness statements. And then over the page, and Stubbs, by the way, of course, is the planning officer.
Where do we find the mention of the 11th of August in your skeleton?
Well, the date of the 11th of August is in the claim form, my lady. In seeking an injunction, that is sought through the claim form, the 11th of August. The deliberative...
So do you mean to say that's the date of the claim form?
That is the date that it was signed off
Yes.
by Miss Say.
That doesn't answer the point with respect. The date of the claim form tells you nothing about the decision on which it was when the decision was made to make a claim. It's the latest date at which the decision was made, but it would be pretty surprising if you hadn't made the decision before you've issued it. So I come back again to whereabouts is there a passage in your skeleton argument that says to the judge the 11th of August is the key date at which I have to, you must take into account the factors that were before the council.
Well, it's not put in those terms, my lady. Those are your ladyship's words. But when we write the deliberative process, that is a mental process of Epping Forest in deciding to seek an injunction, is set out, etc. Over the page, paragraph 126,
Yes.
you'll see it.
Sorry, paragraph
126 at
Yeah.
the top of page
Thank you.
90.
Thank you.
we concluded that the use of Bell Hotel to accommodate asylum seekers was a breach of planning control. If you read it contextually, my lady, it's obvious that what is being said here in our skeleton argument is that these were the matters that were taken into account when we concluded that the use of the Bell Hotel was a breach of planning control. We hadn't reached a conclusion by that before then, because once you've reached a conclusion, there's nothing yet further to conclude. And we did conclude that it was necessary and expedient for that breach of planning control to be restrained by injunction. It reached each of these conclusions after careful and responsible deliberation. And it specifically says there it had internal planning expertise, it called on external legal expertise, it considered all relevant factors, not least whether seeking an injunction was proportionate. No, my lady, it's not in the terms that you have expressed it, but it is pretty clear on any reasonable reading of these two paragraphs of our saying these were the matters that we had before us. They came in the days after the 5th of August, and we reached a conclusion on the basis of it.
The person who took the decision, as I understand it, was Miss Sayers.
Correct.
So the judge has Miss Sayers' evidence as to the decision that she took and when she took it. And looking at her witness statement, I don't see anything in there about the 11th of August.
Well, her witness statement is in the supplementary bundle, tab 26, starting at page 342. And if we look at the way that she concluded her witness statement, paragraph 21, the final paragraph, page 350.
The one beginning at every available opportunity.
And each and every step,
Yes.
step is instituting the proceedings. I've carefully considered the position as to whether there should be a review of the council's action and the decision to apply for injunctive relief. And then she gives, by way of example, following the outcome of the appeals to the Court of Appeal, etc., etc. She has stated there that each and every step, and instigating the proceedings is a step. She's considered the position whether there should be a review of the council's actions. And the reason for that, my lady, is that she had reached a certain point of view on the 5th of August. She got the further material. Having got the further material, which she expressly refers to, she then makes the decision, cross the Rubicon, and start these proceedings.
As I understand it, there was no contemporaneous note of her decision. Is that right?
Yes.
All right, so you say that on a proper reading of her evidence, the judge should have come to the conclusion that the decision was taken on the 11th of August and not on the 5th. That's what it boils down to.
That's when she committed the council to this litigation.
So that's when she took the decision that the application should be made.
Yes.
Right.
What I don't follow is that the judge said in his judgment the decision was taken by her on the 5th of August.
Quite.
Paragraph 124 of the Court of Appeal's judgment in September says the same thing. The judgments go out in draft. I mean, 3 judges in the Court of Appeal are under that illusion, apparently. Then the judgments go out in draft for typographical errors, factual errors, to be drawn to the attention of the court. And I assume no one said, you've got that wrong. It wasn't the 5th, it was the 11th.
My Lord, I don't know. I wasn't at that hearing, is all I can say. It's
Well,
not much of an answer. But,
Well, you were.
no, I was not in the Court of Appeal.
No, I appreciate that, but my questioning embraced also Mr. Justice Mould's judgment. Because he says it was the 5th, so if he got it wrong, someone should have said.
Well, my Lord, I wouldn't have characterised that, no matter how elastic language it is, as a typographical error.
Forgive me, by the time his judgment comes out in draft, it's quite clear how he's using the 5th of August.
It's an obvious. I know that we send the rubric and say it's not an opportunity to re-argue the case, but if there is the most obvious factual error on the face of a judgment, and it's either an uncontentious point or it's something that you say the judge hasn't properly grappled with, it's perfectly in order to say to the judge, with the greatest respect, my lord, you've misunderstood the evidence. It's the 11th. It's always been the 11th. That's our case. Please, will you correct it? He can either say yes or no, but at least he knows that there's an issue about it. But instead, as my lord has pointed out, 3 members of this court, plus Mr. Justice Mould, have all been operating in accordance with your case under an illusion that the date was the 5th.
Well, my lady, this point was put in draft grounds before Mr. Justice Mould. It didn't get terribly far. I don't imagine that if I'd dressed it up in the other way, it would have got any further.
Well, let's say you're right. Let's say that the case was the 11th of August. The question is, where does the argument go next? It makes a difference if, in challenging the judge's exercise of discretion, if as a result of that mistake he failed to take something into account.
Correct, Lord.
So
we remind us.
You've invited us to read the witness statements referred to in your skeleton, the gathering of the evidence, and what I haven't so far detected is some additional point, material planning factor, which he didn't take into account. To be fair, there's Mr. Stubbs, but he expressly refers to Mr. Stubbs' evidence and takes it on board. So what's he missed out? Well, through getting this date wrong.
Ground 2 is concerned with the exercise of his just and convenient discretion to grant an injunction. He takes into account a range of matters. One of the matters that he takes into account is what he characterises as the serious procedural error in Epping Forest not having any planning evidence before bringing this claim. And we say that was simply incorrect. It's not determinative. It is a factor in the exercise of the discretion which we say he got wrong. That's how it's put, my lord.
Give us the paragraph reference where he says that.
199.
199, thank you.
So that's the first of these factors. The second is something that we've already touched on this morning, and that is we say that he gave overwhelming weight to a non-planning consideration, that is the Secretary of State's duties under Section 95 to 98 of the 99 Act. And
at one point in your argument, forgive me if I've misunderstood, I thought you were saying that it's not even, the fact that it's a statutory duty is not even a planning consideration. You describe it as a non-planning consideration.
Well, at this point, my lord, it doesn't matter whether you stick the label planning consideration, non-planning consideration. It is a relevant consideration for just and convenient discretion. There's no issue about that.
Okay.
And it doesn't matter what label you put on it for these purposes.
Your point is that the judge elevated it in a way which was not appropriate
He attached significant weight.
No, you're not trapping me that way.
That's not a trap, that's what he said.
No, but we say it's not a weight question, this.
Well, isn't it? I mean, I thought, sorry, that trying to use neutral language rather than planning language here, when a judge is exercising a discretion, there are various factors that are taken into account. And those factors are weighed up against each other, factors for an injunction, factors against an injunction.
Right.
And ultimately, the judge has to come down one way or the other. And as part of that exercise, the judge will attach, I'm not going to use the word weight, more importance to some than others, but that's a matter for the judge. But you're saying that in an exercise of this kind, the Secretary of State's duty, whilst it is a factor, is one that could not be given the degree of importance that the judge attached to it, and you're now going to explain why that is so.
Well, the way, wouldn't put it like that, if I may say so. The way we've put it is that because it is an injunction under Section 187B as opposed to Section 37 of the Senior
You look
Court,
at planning first.
you look at planning first, and this is the
Right.
structured way that it has to be done. And this is the very point that was made by Lord Justice Simon Brown in the Court of Appeal in the South Bucks case, which received the support of all of the lordships in the House of Lords. You have it in the authorities bundle, tab 4. The passage is at page 63 of the bundle pages, and it's paragraph 42. And what he says is that it's got to be undertaken, this exercise, in a structured and articulated way.
Yeah.
And if you do, then the appropriate conclusion should emerge. And the corollary of that, although he doesn't state it, but the corollary of that is if you don't undertake it in a structured and articulated way, then an inappropriate conclusion may emerge. And that's the problem.
And you say that the structured and articulated way that Lord Justice Simon Brown had in mind was you look at the planning considerations first and then you weigh in any other factors.
In broad terms, yes,
Yes.
my lady.
So coming back to my question, you're treating this other factor as a non-planning consideration. I mean, say for example, you've
Yes.
got a water company which promotes a new sewage treatment plant in order to meet its obligations under the Water Framework Directive, a duty. The need to provide the sewage facility is a relevant planning consideration.
Right.
If it's underpinned by a statutory or policy imperative, why isn't that relevant?
Well, in that situation, it may be, and that's because there's an overlap there between the water issue and the planning
These
issue.
are people in this country who need to be accommodated, and Parliament has imposed a statutory duty on the Secretary of State to deal with it.
Yes.
Why is that not a planning consideration?
Well, it is first and foremost, we say, a obligation on this country under various international treaties which is articulated in these provisions of the 1999 Act. That's what it is first and foremost. Yes, there is necessarily a peripheral impact on planning issues. Most things which have any use of land are going to have some impact on planning issues in one way, shape or form. The question is the nexus. And we say these are not core planning considerations. The core planning considerations are the ones that should have paramountcy in the exercise of a discretion to grant or to refuse an injunction.
Like standard planning considerations like effect on residential amenity. But then, take noise for example. How bad noise is a question of degree. So it may be a core planning consideration, but in a particular case it may have little weight. Back to my lady's question.
Yes,
Ultimately, it's a question of weight.
well, the way I have put it is it's a question of structuring and articulating the exercise of the discretion under Section 187 that we have complaint with. That's the
Yes.
point. So that's second one. Third one is the issue of resulting community tensions from the breach of planning control. And the point here was not whether this was relevant to any application for planning permission. That's not the way we put it. The way we put it is that it went to the exercise of the discretion to grant an injunction, whether it was just and convenient to do so. And the relevant paragraphs in his judgment are at paragraphs 256 to 265.
Sorry, 256.
Sorry, 256 to 265.
Sorry, big pardon.
So it's a question of just and convenient to grant an injunction where the activity in question is creating community tension. And he recognised that it was creating community tension. It's not for the purposes of its relevance for planning permission, it's relevance for the purposes of just and convenient. It's a short point.
I'm not sure I can see a difference because the purpose of Section 187B is to enable an injunction to be granted for planning purposes. planning reasons.
It's in a sense.
Something you rely on elsewhere.
Yes, but in a sense it relates to subground B, because in subground B I said, well, asylum housing policies are not fairly and squarely planning issues.
Yeah.
So too this one. It's not so much that it's a planning issue, it's the fact that it was creating community tension, and that, generally speaking, all other things being equal, is something should weigh in favour of an injunction that will abate those community tensions. That's all. Whereas he looked at it...
It's the short end of a slippery slope, Mr. Coppell, because there are a number of cases which say that unlawful protest should never dictate, should never be a relevant, or the recipe for unlawful protest should never be a relevant factor to dictate to a party how to exercise a discretion. And whilst the judge quite rightly says, well, I've got to take into account the fact that this hostel is creating, or use of this as a hostel as you would describe it, is creating tensions in the community, and he takes that into account, there must be a limit to how far he should go in that regard, because otherwise I'm afraid you can achieve injunctions simply by making a lot of noise about something.
Well, Eddie, it's not the protesters so much as those who
It's
live
the impact on the local amenities.
Exactly. Those living in the vicinity who want peaceful lives,
Yeah.
and are seeing what is happening as a result of it.
Well, I entirely get that. I can entirely understand that if it has an impact upon residential amenity, that is a very important factor from the perspective of the planner. Actually, it's a planning consideration, residential amenity, isn't it?
Well, it is, but it's not solely a planning consideration. It goes to the discretion in 187B. That's the only point there.
All right.
Next one is the judge below reasoned that Somani had been consistent in its position that it didn't need planning permission. But, my lady, what had been done was to confuse the various periods in which asylum seekers were accommodated in the Bell Hotel. There were 3 periods.
Well, before you develop this argument, can I just see why that's relevant to anything? Why does it matter whether Somani were consistent or not?
Because the way that it loomed in the judge's mind in the exercise of his discretion. So if we look in his judgment, my lady, paragraph 164.
Yes.
It's the second half of that paragraph. He maintained that the defendant had been equally consistent in stating its position that accommodating asylum seekers in the 3 periods, the Bell remains in use as a hotel. But in fact, that wasn't the position, and indeed he was critical of Epping Forest in not seeking an injunction from the inception of the 3rd period. That's from April of last year. He said, well, why didn't you? And the chronology went as follows. When it came to the attention of Epping Forest that there was to be this 3rd intake...
They said you need to make a planning application.
You need to make a planning application. There was some toing and froing with Somani, and then Somani said, hey, we have this advice from the Home Office that it's not necessary. At that point, Epping Forest planning officers pulled back. And that's why they didn't take the enforcement action there and then, for which Epping Forest has been criticised, both in the Court of Appeal earlier and in this judgment. That was the reason. It turned out that the Home Office didn't give advice.
This is a later point, though.
This is a later...
This is not the consistency point.
No, it's not.
And I think, to be fair, you're not making a big thing of this, because by the time you get to your reply, what it comes down to is whether or not we read their making of the second application for planning permission as abandoning their previous without prejudice position
that's
when they were silent on it. So it's a relatively, I think fairly, you say it's a small point.
It
by-
is.
A niche
by
point,
itself.
yeah.
A niche
A
point.
niche
nice.
point.
But in fairness, Mr. Coppell, you're looking at the overall cumulative effect of all of these matters that you've picked upon. And so we don't just sort of look at one small point, we have to look at the totality and the way in which that, you say, impacted upon the judge's exercise.
Yes,
of
and
his
you might
judicial
conclude that some are good and some are bad, and you might conclude some that are good are important and some that are good are less important, and you look at the totality.
But you
and
say
ask,
you only need a few anyway. That's
No.
what you said at the beginning.
yes,
I
and then
take
you ask,
that point.
and then you ask yourself at the end, can you be confident that the outcome would have been the same had these what we
Yes.
call mistakes not been made? And the answer we say is no. Then subground E is again a crime one, and what is there said is by the judge is that the local residents' fear of crime could be discounted on the basis that there was a lack of statistical evidence. And what we say in relation to that, and that was paragraph 254, sorry, of the judgment. And what we say in relation to that is, here it was, there had been 6 crimes, some of them serious, very serious, in a very short space of time.
Sorry, there's 6 crimes.
Sorry, 3 crimes in 6 months. I got
Yes.
the numbers
I
round
was
the
going
wrong
to
way.
say,
And
committed by the same person.
no,
No,
not all of them.
No.
No. But you know, one of a sexual nature on a girl.
Yes.
To say that this is not something we say that is very material to the exercise of a discretion, to bring a halt to the source of that, we say is wrong. It's as simple as that. And we didn't need to adduce statistical evidence of how prevalent crime is in this country to know that 3 in the space of 6 months in a small community of this sort of order of crime is well above the norm and is a justified reason for local residents having a fear of crime on the basis of the use that was being made of the Bell Hotel. It is a factor. It can't be zeroed out. So that's E.
But before you leave E, the other part of the judge's reasoning was related to the West Midland case in the Court of Appeal. As I understand it, you don't criticise his analysis based on that decision.
No.
No.
The point is a basic statistical one.
But he added to that this additional factor which you do criticise.
Correct.
Thank you.
One of the small point again is the term of the contract for placement of asylum seekers. He maintained that it wouldn't continue beyond indeed next month of this year's, whereas in fact the contract provided for a quote initial term ending on April 2026, and it contemplated that the use would extend beyond that initial term. And that's the point that we made in our skeleton argument, paragraphs 55 down to 57. Then,
Well, sorry, just make sure I understand this. The contract used the words initial term. Was there anything going beyond that in the contract to indicate it might be extended? Like an option clause, for example?
well, it called the first year of operation the initial term.
I've grasped that.
Yeah. The answer is I don't know offhand, my lord.
At
I'll
least
see if-
there was nothing being put to the judge which went beyond the use of the words initial term.
nothing beyond
Okay,
that, so far
thank
as
you.
I can recollect.
Thank you very much.
Then the next point is the removal of Somani or the Bell Hotel from the non-domestic rating list. It is fair to say, my lady and my lord, that we made quite something of this. It was, we put to the judge, quite an extraordinary thing for Somani to apply, of course, to the VOA for the removal of this hotel from the non-domestic rating list and to call it a single domestic dwelling. your Lordship in particular will know from rating law that in order to do so, you are maintaining that it is no longer being used as a hotel. We, on our side, don't have access to that material. It is
Or as a business.
Or as a business, yes. We, as the local...
Hotel or hostel, you're saying it's not liable to business rates.
Well, that's what they did. That's what they applied successfully.
I'm not sure how it helps on the hotel. This goes to the hotel-hostel distinction, doesn't it, at this point?
But if it's either, it's still a business.
Yes, yes.
Well,
But
it goes to
the other side say this goes back to ground one and whether you're dealing with a material change of use or not. It undermines their case on material change of use.
Yes, but the point is that we don't have access to this material. It's confidential to, of course, Somani and HMRC. We are left with the business of just collecting the rates and told when a change is being made. But we say that it is important that that application was made. It was an application to remove the Bell Hotel from the non-domestic rating list. Non-domestic rating is based on use. The use had been that of a hotel, and we say that that was irreconcilable with the position that it was taking in these proceedings, that there had been no material change of use.
That's the point I'm putting to you.
Yeah.
That's what it goes to.
Yes. And it's fair to say that the judge below, despite my efforts, was dismissive of that.
Well, on the material change of use issue to which this goes, he said, I will defer, paragraph 299, I will defer to Epping on the point. And there is a material, I assume there is a material change of use.
Yes, but it also goes not simply to the change of use, but it also goes to the discretion point to grant.
How?
Because if...
This is an injunction which, if it's going to be granted, is being granted for planning purposes, to promote planning interest.
Yes, and
How does this help?
Because one of the considerations, whether it's an injunction on Section 187B or Section 37 of the Senior Courts Act, you are permitted to take into account is the conduct of the injunctee generally. And we say this is matter that is relevant. This is conduct that is relevant to whether the injunctee's interests in being adversely affected should be something more respected than would be the case if an injunction were granted.
It goes to the balance of convenience.
It goes just and convenient, I should say. Balance of convenience at the interim injunction stage.
Yeah.
Then the second, subground H, I've already touched on. This is the fact that Somani had previously advised the planning department of Epping Forest that placement of asylum seekers was a breach of planning control, we had said, and required the grant of planning permission. And the point is made in our skeleton at paragraph 63 down to 65. And what we say is that there needed to be, in deciding to grant or to refuse an injunction, an even-handed approach. And this demonstrated a lack of even-handedness for the 4 reasons that I've set out in paragraph 64. I'm just conscious of the time.
Yeah.
Junior has to continue. So I will then go to a point that my Lord raised in relation to South Bucks, the South Bucks judgment and the divergence. And this is my little ground J under ground 2. Because what we say is that at the heart of the 4 appeals in South Bucks lay Article 8 of the ECHR, and each of the injunctions in those cases was accepted as constituting an interference with the injunctee's respect for their private life family life and home within the meaning of Article 8.1. And the question in those appeals ultimately arising was whether that interference effected by the injunction was necessary in a democratic society. It comes out most clearly in the judgment of Lord Justice Simon Brown in the Court of Appeal, which one has starting in the bundle of authorities at page 44. And right at the outset, paragraph 2, page 48.
Which paragraph in his judgment?
Paragraph 2, my lord.
2.
Paragraph 2, page 48.
Okay.
He says, at the heart of these appeals, lies Article 8 of the European Convention for the Protection of Human Rights and Fundamental Freedoms. It's not disputed that such removals constitute an interference with the gypsies' right to respect for their private life, family life and home within the meaning of Article 8.1. Nor is it in dispute that the interference is, quote, in accordance with the law and is pursued for the purpose of the protection of the rights of others within the meaning of Article 8.2. The question ultimately arising in these cases, paragraph 3, is therefore whether the interference is, quote, necessary in a democratic society, that is to say, whether it answers to a pressing social need and in particular is proportionate to the legitimate aim pursued. So that was, in the words of Lord Justice Simon Brown, at the heart of those appeals, and there was no change of heart when it went to the House of Lords. It remained that. That isn't the case here. We are concerned with a injunctee who is a commercial operator, albeit that there are third parties who, of course, are being accommodated. But it doesn't have the same Article 8 immediacy that it did in the South Bucks case. And so that's partly why I said in relation to the broader issue, it's time for this court.
Well, I understand that. Very interesting point. But we need to see how, we need to see where it goes. Because as I understand it on the other side, they say this point wasn't taken before the judge, but whether it was or whether it wasn't. The critical question is, how would the South Bucks criteria change to accommodate a purely commercial, non-Article 8 case? And I don't see you dealing with that in your skeleton at all, other than to say they're making a lot of money. Have I missed something?
Well, you've summarised in 2 sentences in a fashion what we say, because we say at the heart of the South Bucks consideration and the methodology which was applied by the Court of Appeal and then the House of Lords in the exercise of discretion. It was driven by what Lord Justice Simon Brown described as being at the heart of it, namely Article 8, and that is not here.
No.
So it's going to result in a different application.
No, you haven't got Article 8 as an argument against the grant of injunction, weighing against the other planning considerations.
Not directly, anyway.
Yes, I mean,
indirectly,
yes.
you have.
Yeah, but even before you get there, you've got the need arguments that are being put forward. So
I would be the first to...
But the real question, forgive me, is since you say this is a compelling reason for an appeal to take place, how would the principles change? Other than simply saying Article 8 doesn't apply, which we know anyway.
The principles would change because the structured approach which was undertaken by the Court of Appeal and then the House of Lords in that case would change, and what would be in the balance and the importance to be accorded to them in the balance would be altered, and that's what we say should have been done
But you're
here.
keeping us on the edge of our seats to wait to find out what the change actually is in this different structure.
But the change is that greater importance would be accorded to the planning considerations that animated the local planning authority in seeking an injunction in the first place.
Even I understand that. I mean, if you have nothing to put in the balance against the grant of an injunction in lieu of Article 8, obviously the planning considerations will have their weight and there's nothing to weigh against them. But I don't see how this. I'm asking you about what the difference is of approach, principle, not waiting.
In broad terms, what happened here, we say, is that the judge below used what I would call the 1999 Act provisions as a sort of, as the equivalent of the Article 8 position in South Bucks. And we say that that is incorrect. He shouldn't have done so. And it completely changes the outcome and the conspectus of factors to be taken into account. That's the point.
Thank you.
So that, unless I have any questions, or there are any questions from the bench in relation to the second round. The second round, my learned junior.
I think we've grilled you quite enough,
right.
Mr. Coppell.
I like to be well done.
Miss Peter.
Lady Bellwood, in ground 3, the council seeks to appeal the order that the council pay the costs of the first intervenor in full. The starting point is that the cost position of an intervenor is not the same as that of an original party. Cost orders in favour of intervenors are not made as a matter of course. This is because, unlike a defendant, the claimant has not chosen to involve the intervenor in the proceedings. So in order to justify burdening the claimant with a second set of costs, the court must ask itself whether there is a good reason to require the unsuccessful claimant to pay a second set of costs. And the court must answer that question on a principal basis, setting out its reasons for doing so in the order. So if I may turn to the order in this case, it's at tab 4, page 52. And the reasons in respect of the cost order are at paragraph 5.
Sorry. Good. Tab 4 and then
Bottom of page 52.
52, sorry.
It's paragraph 5 of the reasons.
I'm sorry, page 51.
Well, in my bundle it's 52, but don't worry about it.
Paragraph
I think there was an updated one.
Yeah, don't worry.
So the reasons are essentially threefold. Firstly, that the potential impact of the claim extended beyond those accommodated at the Bell Hotel to those accommodated at other hotels. And so as a result, it was in the Secretary of State's interest to participate in and defend the claim.
And you say, well, the fact that it's in the judge has identified that there's an interest in participation may be a reason to let them intervene, but it's not necessarily a reason to make you pay their costs.
Yes, it's not sufficient.
Yes.
And I'll come to the test in a moment. Just looking at the second and third reasons. So the second reason is the defendant was not in a position to apprise the court of the wider asylum context. And the third reason, at the end of the paragraph, that the Secretary of State had demonstrated a separate issue in the claim from that raised by Somani.
Yeah.
So I'll deal with those each in turn. The first two reasons are not the orthodox basis for an unsuccessful party to be required to pay the costs of an intervenor. And we say that the third reason simply doesn't bear analysis. Before considering the reasons in detail, it is important to note that there's nothing in those reasons which suggests that the court took into account the fact that the council is a local authority that was making an application to defend the public interest in enforcing planning control. And that's important because, as we noted, the criteria in judicial review proceedings are set out in statute. And the legislature in judicial review proceedings has provided that an applicant shall not be ordered to pay an intervenor's costs, save in exceptional orthodox basis for departing from the standard position is that an intervenor should not be awarded its costs as a matter of principle, and that's set out in the Bolton case, which is referred to in the authorities that we've referred to in the bundle. So the orthodox principle is that either the intervenor must have raised a separate issue germane to the determination of the claim and that hasn't been covered by the existing parties, or the intervenor has an interest in the proceedings that requires separate representation from the existing parties.
Hasn't the judge found both?
Well, no. In terms of the issue, I apologise, in terms of the interest, the judge did state that there was an interest, but it wasn't argued by any of the parties, and the judge didn't appear to consider in his reasons that it was an interest that required separate representation. And indeed, in this case, it would be difficult to say that it is an interest that required separate representation. That sort of a situation is unlikely to be commonplace. But for example, it might be a situation where an issue of national security arises for one of the parties, and as a result, that party is not able or willing to instruct the same lawyers and counsel as another party in the proceedings. So those unusual circumstances.
So does there have to be effectively a conflict between the intervenor and the defendant to the proceedings?
I think a conflict is a good example of one instance when it would be inappropriate for the same counsel to represent two parties.
Well, what other circumstances are there? I mean, you might get a situation where the interest of the intervenor is I'm using a small p, a political interest, an interest which is a matter of policy as opposed to the planning merits, and that's what the Secretary of State is doing here. They're saying, well, we're under a statutory duty to house asylum seekers, and we have a vested interest in ensuring that nothing happens in this dispute to trespass upon that. Why aren't they entitled to instruct separate counsel to argue that sort of point?
They are fully entitled to instruct separate counsel. The question is whether or not the unsuccessful party should have to
Pay for it, yes, but I thought you're saying one of the reasons that the unsuccessful party should not have to pay for it is that they should instruct the same counsel.
Well, that they could have instructed the same counsel, and it would have been in accordance with the overriding objective for that to have been done.
Yes, all right.
So I think perhaps a useful analogy is the Barclay-Burke case. And in that case, the financial ombudsman was an intervening party. In that case, it is clear that the financial ombudsman did have a separate interest in the outcome of the proceedings. But nevertheless, it was not an interest where it was justified for a separate counsel to be instructed. So on that basis, although the financial ombudsman was entitled to intervene, applying the test in Bolton, the judge found that the costs of the financial ombudsman should not be borne by the unsuccessful party. That would not be fair.
Yeah.
I think the important point is that if there is a wider interest, that's not a wider interest that is shared by the party who brings the
All the
claim.
more reason why you shouldn't have to pay.
Exactly.
Get that point.
So I think that deals with the first two reasons in the order of Mr. Justice Mould. On the third reason, and that is that the Secretary of State had demonstrated a separate issue that was not covered by counsel for Somani. We say this does not bear analysis, and that's because the issues in the proceedings were threefold. Firstly, whether there was an actual or apprehended breach of planning control. Secondly, Secretary of State was, of course, entitled to put forward further evidence and argument about the wider context of the need for asylum accommodation. But the fact that she did so didn't import a further and separate issue into the proceedings. And we say that to find that the Secretary of State's interest in the outcome was a separate issue, so the interest in the wider situation would be something that would open the floodgates to any number of parties who have an interest in the outcome in injunctive proceedings, and in other circumstances they may be manifold, to those parties intervening, being entitled to their costs, and as a result there being a chilling effect on claimants who wish to seek an injunction because of the possibility that they would be facing an unquantifiable costs bill.
Yes.
So, my lady, my lord, that's our point on ground 3. Ground 4 is a short ground, and in ground 4 the council seeks to appeal against the order that it pay the sum of £95,000 on account of costs. That figure was derived from a statement of costs, which was served by Somani, late without requesting permission to do so, and after the last date for submissions in the timetable agreed between the parties. Council was not invited to comment on the schedule. It should have been, given that its rights were affected by the decision of the judge to order a payment on account of costs. And if the council had been allowed to comment, it would have, as we've set out in our skeleton, have had some substantive points to
So
make.
this is really a procedurally unfair point, isn't it? You're saying you weren't given a proper opportunity, even if in principle it was right to order you to pay some costs in relation to somebody, then if a cost schedule is produced late in the day and a payment on account is demanded on the basis of that, you should at least be given an opportunity to say, I don't think these figures are right for these reasons. Yes.
Absolutely, my lady, and that would have changed matters because we say that the submissions we would have made would have meant the starting point adopted by the judge when adopting a rough and ready approach for
Yes.
50% would have been different
Yes.
and significantly different in particular because VAT had been added, the VAT of 20% had been added to the figure, and that was taken into account when the calculation was made.
So this point doesn't go to the principle of making an order for payment of costs on account. It goes to the quantification.
Indeed.
And it depends on, do you say that there wasn't sufficient time to make the positive points that you set out in the skeleton? I think there were 6 days.
Well, the chronology was that the parties agreed a timetable
Yes,
for
of
the
course.
service of
And they were late.
submissions and
They were late.
submissions.
But taking that on board, I think we're told there were 6 days available. Is it being said that within the 6 days the submissions couldn't have been made?
So it wasn't 6 days, to be fair.
It wa- What was it?
The cost schedule was served on Friday the 21st.
Yes.
The order was made on Tuesday, the Tuesday the 25th.
So basically you had one working day.
Well, we didn't have that time because by that point the time for submissions had closed. The agreed timetable.
Yes, but they've broken the timetable. I mean, that's not an answer, is it? If they're late, then you can respond. I thought that the point
Or
you're
ask
making,
for more time.
or ask for more time. So you could on the Monday have said, "Help! They've broken the agreed timetable. You're bouncing us into this. Please, Judge, don't make an order just yet because we want to respond to this schedule that's just arrived."
Well, we could have, but what should have happened instead, we say, is that the judge should have invited submissions because the judge was going to be making a decision on
Right.
a document. And as a matter of due process,
Yeah.
he should have been entitled to comment on that.
Right.
There was no provision in the we went
So you
shopping
say it's a matter for the judge. So the judge should have proactively said, "Oh, they're late. I'm not going to make a decision on the basis of this late submission," without actively going back to the party who's at the receiving end and asking and saying to them, "Is there anything you want to say about it?" Because that's the fair thing to do.
Absolutely.
Yes.
It would have been an easy matter for him to set a short deadline for further comments.
Yeah. Okay. Thank you very much, Ms. Peter. Ms. Wheatley.
My lady, my lord, I'll take the submissions in order, if I may, and I'll be as short as I can. My lord, on the issue of compelling reason, the issue of the sort of national importance of this issue, prevalence of this issue in the media, the need to have a resolution on material change of use in these circumstances of asylum seeker accommodation. Those are all countered by the fact that over a number of years now, there has been an opportunity, as my lord pointed out, for any local planning authority who has this issue to bring enforcement proceedings and bring an enforcement notice and have the position clarified in that way by the body that is accorded that function by the parliamentary scheme, by the statutory scheme. And indeed, in this particular case, my lady, the chronology shows, and you can see this on claim bundle page 46, that even in this particular case, there's already been 2 previous periods where this hotel had been used for accommodation of asylum seekers. And in particular, the second period was from October 2022 to April 2024. And there was no attempt there during that period to take enforcement action. Of course, that could have been done if it was so important to clarify this material change of use point.
Well, that's a good forensic argument, but Mr. Coppell says that matters sort of came to a head really with period 3, where the planning considerations, residential amenity and so forth changed effectively as a result of disquiet in the neighbourhood, if I put it that way, with the criminal offences and so forth. And Parliament has specifically given an option to go down this route, and the council, acting perfectly properly, says Mr. Coppell, decided that they were going to make an application for an injunction. They took planning considerations into account. If they're allowed to do it this way by Parliament, then what is wrong with doing it this way? Even if it creates a shortcut, there may be reasons of expediency to address the situation head on faster than going down the enforcement route. I think that's one of the points you made.
Well, my lady, that's of course true, but those issues and the principles about whether to grant an injunction or not were carefully gone through by Mr. Justice Mould.
So you're saying basically that the other compelling reasons doesn't add much to the mix in terms, I'm using the vernacular. Yeah. Either Mr. Coppell's got an arguable point on his grounds or he hasn't, and he's not going to make it any better by saying there are other compelling reasons. Is that really what...
My lady, yes. And of course, in terms of the jurisdiction under the power under the injunction, yeah. The urgency, it is right that it can be brought when other enforcement action hasn't been taken. But the instances that thread through the South Bucks case yeah. are where it's an apprehended breach, where there's obviously a very good reason to take action before the situation changes, yes. or where it's a last resort, where other actions haven't proved fruit. So you've taken an enforcement action, you've prosecuted, but you still haven't got them to move or take down the building or do whatever you're seeking. And that's really where that power comes in. Yeah. And the Supreme Court says that it's quite rare, really, if you haven't tried enforcement action, that is a factor against exercising direct discretion. So that's the issue on compelling reason. The second part of the compelling reason relates to ground 4, which doesn't concern me, so I'll leave that to my learned friend. In relation to ground 1, I do slightly struggle with exactly what it's directed towards, because as my lord pointed out, and as we've pointed out in our skeletons, the judge made an assumption against us, against the respondents, accepting that the local planning authority had a reasonable basis, even though he had concerns about their decision making, that they had a reasonable basis for alleging the breach of planning control. And on that basis, he assumed if it were a breach of planning control, what are the planning and environmental consequences of that, and are they sufficiently grave to justify an injunction? And but my learned friend says, well, yes, but he didn't necessarily take into account all the factors that would go to the decision of whether there's a breach, and then carry them forward to the consequences. But again, as
Well, either he took into account all the factors or he didn't.
my lady, yes, and my learned friend hasn't been able to point to any factor that was material to the change of use decision, and that was relevant to the planning or environmental harms that was not taken into account.
Yeah.
The judge expressly dealt with all factors going to the materiality of the change of use insofar as they fed into that question. He didn't have to go through every other factor, like whether they had tea-making facilities in their room, because that wasn't a planning issue. It may have been relevant to the extent of the change of use, but it wasn't a planning issue. And my lady, the judge made very clear reasons as to why it was not appropriate. He didn't say he couldn't go down that route, but it was not appropriate for him to go down that route, not just and convenient to go down that route, by reference to the statutory scheme and the allocation of functions. And he also drew attention to the fact that where this issue has been considered previously by the courts, that's in the scenario of a review of a primary decision maker's judgment as to whether something is a breach of planning control, not the court having to take that primary decision for itself. And he explained why that was, was undesirable, not necessarily impossible, but undesirable. And my lady, that moves me on to a similar point in relation to the declaration concern. I don't think it's disputed between us that it's a discretionary remedy. Indeed, my learned friend put it in terms of whether it serves a useful purpose when he sought the injunction. And in the Rolls-Royce case that we refer to, which is page 191 of the authorities. Yeah, page 191, paragraph 120, sets out, and I know they're specific to that case, but it's really the sort of factors that are relevant to discretion. And one is, in all cases, this is paragraph 120, subparagraph 7, in all cases, assuming that the other tests are satisfied, the court must ask, is this the most effective way of resolving the issues raised? In answering that question, it must consider the other options of resolving this issue. So far as the issue of breach of planning control was an issue before the court, and we say it wasn't in terms anyway, it was the issue of discretion on the injunction, but insofar as it could have been, the judge fairly considered whether it was appropriate for him to resolve that issue or whether it was appropriate for the bodies accorded that function under the statutory scheme. And that was, we say, the appropriate way of going about it. So my lady, unless there's any questions on ground one, I'll just move on to some of the points in ground two. I'm not covering them all, we've split them between us, but I'll just touch on a few points. My lady, in relation to ground 2A, which is the date of the decision, I do find this quite confounding because none of this was raised in the High Court, and in the Court of Appeal proceedings I wasn't at, but I actually watched them. The counsel for the council at the time was asked when was the decision made, and he confirmed it was the 5th of August. It wasn't Mr. Coppell, but it was his predecessor. And my lady, we sat through the evidence of Ms. Sayers, who has the delegated authority to make the decision on behalf of the council. At no point was it a suggestion put to her in re-examination or otherwise, that the decision was not made on the 5th of August or that it was reviewed afterwards. My recollection is that the judge did ask about her paragraph 21, which is the paragraph you were drawing attention to earlier, about her reviewing the decision. And she said, yes, she did sort of agonise about it, but she couldn't point, and she was asked specifically, she couldn't point to any new factors she considered or any new notes she made as to her decision-making process. And really, the third point on this is, where does this all go? Because if you look at the judge's conclusions on the decision making, it's at paragraph, I think it's 199 and 284, so page 114 and 137 of the judgment, where...
So 199 and...
So
284.
Yeah, 199, and so if we start with 199, which is what page 114, that's where the serious procedural error is described, and that is, of course, not taking any minute or contemporaneous note, contrary to the express provision of the Constitution, the Council's Constitution. So that was the serious procedural error, and of course that's not changed by the date of, supposed date of any decision. And then, my lord, my lady, if we look at page 1...
So it's not as if that error, if it be an error, was altered on the 11th of August.
No. Well, no, I mean, it was just the claim recorded that it was made. And then paragraph 284, page 137. This is where the concerns about the propriety of the decision making are set
Failing
out.
to prepare a contemporary record again.
Again, that, but then also the consequences of that, of real uncertainty as to the matters which the decision maker took into account in reaching that decision. Now, again, these were matters Ms Sayers was asked directly in evidence, and she confirmed that she did not consult directly with the claimant's planning officers. It's a matter of record that there was no attempt to engage with the defendant or the Home Office in relation to the proposed enforcement action. There is, there's nothing even in the later witness statements to suggest that the third point, that the council took into account the local plan, the enforcement policy in the plan, the council's enforcement policy, or the national policy on enforcement action in the PPG, in the planning practice guidance and that's about an injunction being a last resort. So those are all factors that the judge took into account in criticising, or those are the aspects that the judge criticised in regard to the council's decision making. And none of those, the timing of the decision or the alleged timing would not have made any difference to any of those points in any event. But even if, and I don't accept this, but even if the witness statements that were mustered, in my learned friend's words, prior to the decision being issued, even if they illuminated any of these issues, which I don't think they did, there's no evidence that Ms Sayers took them into account and revisited her decision. There's absolutely no evidence of that she reviewed her decision taken on the 5th of August. So it's a complete non-point in my submission. The next point that I'm dealing with, I'll leave my learned friend for the Home Office to deal with some of the intervening ones, but the consistency point. My lord encapsulated what I was going to say in submission, that the only issue here that could possibly be said to be inconsistency is that there was a moment in April 2025 where my client provisionally agreed to make a planning application. There was no suggestion that was made on any different, or that would have been made on any different basis to the previous application, which had been expressly made on a without prejudice basis to whether there was a material change of use. There was no acceptance, certainly no express acceptance that, oh, I've now realised, I've now seen the light, I now consider this to be a breach of planning control, and it's on that basis that I'll make the application. Yeah. It was a simple matter of expediency and acceding to the request, unless and until the Home Office directed him otherwise. And that links in with another point which my learned friend didn't elaborate on in oral submissions at all. I don't know whether you need me to deal with it, but that's the point about the alleged serious misrepresentation. I mean, I am concerned about that because it is a serious allegation against my client. Of course, that reference to the Home Office advice, the term advice is used in a colloquial terms about what the Home Office was advising my client to do and directing my client to do, and you can see that very clearly in the two references in the judgment which quote those points. If you look at first of all page 91 of the bundle,
paragraph.
Paragraph 131. This is the email from my client's representative to the planning officer on 15th of May. It's talks about received a new direction from the Home Office via CTN, so via the agent. The Home Office has advised that in the government's opinion, the hotel is contracted on exclusive use terms of the hotel, not a hostel, and so they did not support a change of use application. And then to the end of that paragraph, accordingly, I've been instructed not to proceed with the change of use application. My Lord, my Lady, there was no suggestion there that my client had been seeking kind of professional planning advice from the Home Office. And indeed, that wasn't the way it was understood, even by the council. And you can see this at page 94, paragraph 143. This is how the council set out the position in a statement or a publication. You see, it says on the second sentence of the second paragraph, on this occasion the operator of the premises declined to do so under advice from central government, which considers the premises to have been contracted continued use as a hotel for which planning permission is not required. We are seeking advice, we're seeking our own advice on the government's assertion. So there's no suggestion that the council understood there was some legal opinion from the Home Office to my client that my client was relying on and was hiding. I mean, it's just a nonsense. There's no, absolutely no question of any misrepresentation, let alone any serious representation on behalf of my client. Then, just quickly, the other points. Just quickly on the fear of crime point, my Lord, my Lady, the judge was very clear about separating the two aspects of Midlands probation officer, which is whether there is an actual kind of reasonable basis for fear of crime and an understandable basis. And the judge was very clear that there was in this case. It was understandable that the public were worried. But the second issue is whether that is connected with the use complained of, the use of the hotel, not the use by any particular occupant of the hotel, but the use of the hotel for accommodating asylum seekers. There has to be that inherent link, that there's a greater propensity for asylum seekers to commit crime. And the judge squarely addressed this at 248, paragraph 248, page 126, where he said, in the middle of that paragraph, I should need to see an evidence-based and clear and statistically sound analysis of the relative incidence of crime and antisocial behaviour amongst asylum seekers as a defined cohort of persons in comparison to a properly defined cohort of the settled population.
In other words, when he's asking for statistical evidence, he's not asking for statistics of what particular individuals may have done who were housed there, but is it likely to increase crime in this area because there is some sound basis for saying that asylum seekers are more likely to commit serious criminal activity than anybody else?
My Lady, yes.
What it really boils down to.
And a sound statistical basis is not just picking, you have to work out your sample size, population size, look at also all the periods. My learned friend's just looking at 6 months. This has been used for asylum seekers over 5 years, and numbers of them. But anyway, it's a small sample size. You'd have to look at across the country. Statistical evidence is a science. It's not just putting a few figures in the air. And there's absolutely no evidence of that kind in this case. The rating position, was an issue raised, fairly put. It did go to whether there was a breach of planning control, and of course, not to the balance of convenience, the just and convenience test. This was dealt with in evidence, my client did put in a witness statement explaining what had happened in relation to the rating position, that their rating agents had made this application to the valuation officer on the basis of the length of the contract. That's what he was told. My client is not an expert in rating. He has now asked the rating agent to review the position and go back to the valuation officer. But there was never any... my client didn't have any understanding of the overlap between the planning issue and the rating issue. And in any event, it doesn't take the position any further in circumstances where the court had decided to make an assumption against my client that there was a reasonable basis for a breach of planning control in any event, so it didn't add anything. Then I'm just checking.
Do we have the witness statement?
We don't in the evidence. It was in the bundle
Before the judge.
Before the judge. I mean, it's in the trial bundle B. I've got the reference, so we can, if it helps, I can ask for it to be emailed across.
I mean, the expert didn't do it off his own bat. He would have been instructed.
Yes. Well, let me just. Could I just find the evidence?
And basically, I think, I appreciate the sections which deal with what is a dwelling for the purposes of council tax.
Yes.
Are not user-friendly. But I think most people understand that it's dealing with a dwelling, residential accommodation. And most people understand that rates are dealing with the occupation of property for business purposes.
Yes, I mean...
So it is a little bit surprising.
My lord, it is. I don't know the extent... I mean, my client said that they contacted specialist agent to handle business rates and any relief across the businesses. In relation to the Bell Hotel, we provided them with the the Fine Fare Office 2022 long-term asylum accommodation contract, since my understanding is that the change of rate is dependent on the hotel operating under a long-term contract. Because the specialist agent had confirmed to me that this is not a planning matter and the valuation of the work does not consider the use of the hotel because it only considers the nature of the booking contract, at no point had we had any discussion.
Yeah, the focus is on occupation.
Yes, that was what he was led to believe by discussions with his agent. And he says, given the issue is raised, we've asked the agent to review the situation. I've instructed them to refer to the matter back to the valuation office because the hotel, although operating under a long-term contract, continues to operate as a hotel as explained in my evidence. I've made it clear that the valuation office needs this clarification and that should this result in a change back to business rates, then we're happy to accept that. So that was my client's evidence to the court below on that matter. Then, sorry, let me just check that.
Because you had witness statements, including one from Mr. Salmon.
Yes, that was in Mr. Salmon's third witness statement.
Yes.
Yeah.
Was he cross-examined?
He was cross-examined, yes.
Yes, that's paragraph 24. I see. So that's where it would have been raised.
Yeah.
Thank you.
Then, I think, just check, I think I might have found it. Oh, the contract, the date of the contract, my lord, the front page of the contract, which again was in the bundle before the judge, isn't in the bundle before you. The front page simply had the dates 24th of March 2025 to 24th of March 2026. But it is right that the definitions page had initial term, and it was the 12-month period ending with the 24th of March 2026, unless brought to an end earlier. There was no provision, to my recollection, although I haven't checked it again, that making provision for a kind of call-on further term, and certainly there was no evidence that there were any discussions, and I think my recollection is Mr. Salmon was asked directly about that. And in any event, the court expressly understood the position because the court referred to the initial term nomenclature in the judgment, and you can see that at yes, paragraph 14 of the judgment, page 59, refers to the initial term of 12 months, and then throughout where the court references the use being brought to a close no later than April 2026, he refers to the current use of the bell coming to an end by 2026. So not ruling out the possibility. I mean, there's always a possibility there could be an extension. There's always a possibility there could be a new contract. But there certainly was no evidence at the time, and I don't have any instructions that there is any evidence now as to whether or not that contract will be extended.
I'm not sure how significant this is, because this was an application for a permanent injunction.
Well, yes. Well, I mean, I suppose this, to be fair, there are references where the judge refers to the current use being temporary. So there are, the judge does reference that it's likely to cease by April 2026. When
you can see the argument that that it would be wrong for the court to grant a permanent injunction if the use objected to is going to come to an end very shortly. So that's Mr. Coppell's point, I think.
Yes, and I think it's fair to say that the judge...
If the judge gets that wrong, and it isn't going to come, or it isn't obvious that it's going to come to a halt very shortly, then you've got to factor that into the considerations.
Yes, and it's in that light that the judge refers in a couple of places to the use being temporary. And then just check. I don't think my learned friend in his written submissions relates to the fact that the even-handedness of Somani not seeking planning permission, knowing that...
This is his paragraph 24, and he's invited us to read that again. He didn't really push it orally.
The short point is that it's for the... to the extent there's an imbalance between the duties on the planning authority and the duties on an owner, that's part of the planning system. If the planning authority is going to take draconian enforcement action, there are duties, sort of fairness duties on it to warn and explain things to the person who's going to direct that action towards. There's no such duties on the owner to make the planning authority aware of what it's doing. In this case, it did anyway, make the local planning authority aware, make the council aware. And my lord is recognised in Great Yarmouth, and it's in the High Court decision in Great Yarmouth, and it's also reiterated by the judge in this case at paragraph 294, page 139, that there's no abuse of the planning system by a owner or an operator continuing disputed activity even while enforcement action's ongoing. That's how the situation works, that an enforcement notice can be brought and the use can be continued, and it's unless and until it's an appeal is determined against the owner that the activity is required to come to a halt. So that's part of the same system. But it's not that there aren't those similar duties on the owner and the local planning authority. Then I just want to make one comment. I know my learned friend, if he has time, is going to make a comment, but just in terms of the difference between South Bucks and because it relates to Article 8, that is a distinction without a difference in terms of the approach. That was one of the strong countervailing factor in that case. There are strong countervailing factors in this case which relate to the Home Office's statutory duties. And once you start arguing about that difference, it reduces down to the issue of weight again. And my lady, my lord, other countervailing factors which I could take you to, but are clearly in the judgment, are things like the flagrancy of the breach, the lack of flagrancy of the breach, the council's decision-making, the poor council's decision-making. Those are clearly factors identified in the South Bucks judgment as being relevant to the exercise of discretion. And those factors are, by no means, there's no principal basis on which those factors could be connected to the fact that it's an Article 8 issue, or an Article 8, there's a fact giving rise to Article 8, as opposed to anything else. They are part of the general principles for the discretion, rather than connected to the Article 8 issue. Oh, I should just quickly deal with the cost point. My lady, my learned friends were never backward in coming forwards in terms of communications to the court. There was ample opportunity to raise this issue, raise the issue on the cost schedule, to ask for more time to do so. The order was, I think it was made on the 25th. We didn't actually get it till the 27th. The cost schedule was sent in on the 21st. There was an opportunity to say, oh, please let us have time to respond. But in any event, this is a rough and ready jurisdiction. The 50% advanced payment, in reality, wouldn't have made any difference, even if those points had been made. Those are points for detailed assessment, not for the principle of making a payment on account. So, unless there's anything else I can assist you with.
I think what the main point that Miss Peter makes in relation to that is that the starting point would be different, because although you might say, well, a rough and ready approach of 50% would cater for all of the things that you'd say at a later stage in detailed assessment. If you start from the wrong figure, the 50% is going to be higher than if you start with a lower figure. That's the point, isn't it?
Well, I understand the point, my lady, but nevertheless, the points that are being made are points for detailed assessment.
Right.
And that would, I would envisage, my lord,
The VAT point ought to be one, I'm sorry to say it, but it ought to be blindingly obvious to the judges dealing with it, actually, if there's VAT in a cost schedule. But there we go. Even Homer can nod.
but yes, I don't think I have anything to add.
All right, thank you, Ms. Wickham.
Thank you.
Mr. Strawn.
My lady and my lord, I adopt my learned friend's submissions. I'm going to try and avoid any repetition, but there are one or two things that have been left over for me to cover.
Yes.
Just first of all, compelling reason. Advanced today is the compelling reason that there needs to be some revisiting of the approach to costs in relation to these sorts of cases. That's my learned friend's second compelling reason. My lord and lady, you only had to look at the way ground 3 was argued today by reference to established principles, namely the Bolton principle, and it was which the judge clearly had in mind, as I'll take you to when we go to his order, to realise there isn't any compelling reason for the court to revisit this issue in terms of costs. They're well-established principles, and indeed my learned friend's complaint under ground 3 is about the application of those principles rather than the need to revisit them. However, insofar as this case is said to provide a basis for revisiting, it would be important to remember the context covered by the Court of Appeal, this court previously, in allowing the Secretary of State to intervene, that there was a complete failure, for example, to send any pre-action protocol correspondence to the Home Secretary, bearing in mind the obvious interest that there would be. There obviously was, the application was allowed to the Secretary of State then to become a party, but the Council didn't seek to impose any cost restriction or other constraints on that intervention. So
Well, they might say, Mr. Strawn, that they wouldn't have expected to be exposed to your costs because you're intervening, because that's not the norm.
Well, my lady, as I'll come to under ground 3, the norm is if someone does have a separate issue that they're raising,
Exactly.
which is what the Court of Appeal identified
Yes.
in allowing them in,
Yes.
the Secretary of State in,
Yes.
and in any event, a reason to be separately represented, which again the Court of Appeal was recognising in allowing the Home Secretary to take part in the final proceedings. then of course the expectation would be, yes, you certainly are potentially exposed to the costs. So, my lady, that's the compelling reason. I'll come back to the detail of the ground 3 in very shortly. Just picking up on the other points then. So far as ground 1 is concerned, I don't add anything further to what my learned friend said, other than to draw your attention to the conflation in the appellant's argument between material change of use and consequences of that use, not a conflation that the judge made below, because of course he assumed a material change of use and then dealt with the consequences. In the course of argument, my lady raised, I think, the question about the loss of accommodation, for example, and as a good example of precisely how the judge did deal with the consequences, that's covered in paragraph 287 of the judgment, where the judge recognised that loss of accommodation was contrary to the local plan, but didn't regard that and weighed it in the balance as a serious harm, not least because of the temporary nature, but also because of the evidence that had been given about the hotel needing this revenue in order to refurbish itself to come into what my learned friend calls normal hotel use in due course. So leave aside the merits of that, it's a clear example of the judge dealing with the consequences of the assumption he made. And my learned friend hasn't identified any omission in the judge's careful analysis of that matter. Ground 2A was the wrong date. Could I just add to what's already been said about the serious procedural error? My learned friend, Mr. Koppel, characterised it as a serious procedural error was not having taken planning advice, but that's not what the judge said. See paragraph 199.
Sorry, paragraph?
199 of the judgment. The procedural error was not having a record of what...
Not having a record.
Exactly. So my learned friend's ground of appeal starts off on the wrong premise. And of course it goes nowhere because having identified that serious procedural error, the judge then went on nonetheless to look at all of the reasons that were being advanced for seeking an injunction, including the planning reasons that weren't recorded but were now being advanced, in rejecting the basis for an injunction in the analysis. So this is an incorrect attack on the judge for what he actually said, but it absolutely goes nowhere. Ground 2B is the question of the Secretary of State's duty to accommodate and the weight that carried in the balance. And all I would just add to the debate that's already been had is, of course it's a planning consideration. And in the course of argument, there was discussion, for example, about duties under water obligations. I just draw the other example, affordable housing, duties to house people who may require affordable housing. Clearly a planning consideration, one that features large in many planning cases, the need for affordable housing and how that then translates into how land is used. Here there is a need to accommodate asylum seekers in these circumstances. It's clearly a land use consideration. How it's then addressed is a matter of weight for the judge. Ground 2C, I'm not sure I need to say very much about, but that was the alleged misunderstanding on residential immunity and community tensions. But in our submission, it's clearly dealt with by the judge in paragraphs 285 to 90, including the relevance of community tensions. And this is nothing more than an attack on the judge's discretion, having carefully considered the issue. Ground 2E was the fear of crime. My learned friend says that the judge discounted the resident's fear of crime based on the events that had happened. That's not correct. Again, he's not reading the judgment correctly. The judge identified the statistical problem that my learned friend's already tackled, but concluded that there was a reasonable based fear which he took into account, but then he went on to deal with the second part of the West Midlands case, which is to look at whether it's related to the use, and it's on that basis he reached the conclusions he did, and there's no attack on that. Round 2J is the attempt to suggest that South Buckinghamshire in the House of Lords should be distinguished on the basis that it's confined to Article 8 cases. My own friend, Ms Wigley, has already made some of the submissions I wanted to make. I don't repeat those. But of course, if one goes back to what Lord Justice Simon Brown said in the Court of Appeal, he then, the next paragraph you won't take into, paragraph 4, talks about what's at the central issue for determination of the Court of Appeal was whether or not they had an original jurisdiction or not, or whether it was a review jurisdiction. And it's in those circumstances that there follows the analysis, as it did in the House of Lords, as to whether or not there is an original jurisdiction and the reasons for that, and then the factors to take into account in applying that original jurisdiction. And of course, there isn't any basis for distinguishing it because it involved Article 8. And my own friend hasn't identified the different methodology he would advocate. Not least, he didn't identify it to the judge below, but he hasn't identified it to the Court of Appeal today, even if the court were willing to entertain it. I've rattled through those. I just wanted then to tackle ground 3, the cost point, but if I can assist you any further on those other grounds before I move on to that, I'm sure the court will let me know.
Thank you.
My lady, then, ground 3, this is the judge's order to award the Secretary of State her costs of taking part. Just first of all, a basic word of caution, if I may, about the conflation again of the approach to an intervener in a judicial review claim and Section 86 of the 2015 Act, which now makes particular provision for that, and an intervener for the purposes of CPR Part 19. They are not the same. Someone who joins proceedings under CPR Part 19 on their own application is referred to as an intervener, but the test for that intervention is set out in CPR 19, including the nature of the issue that they want to raise. By contrast, in judicial review, there is a claimant, defendant, and of course, interested parties. And the interested parties are those with an interest in the outcome subject to their own tests, in respect of whom costs may be awarded, for example, in relation to acknowledgements of service, but also on standard Bolton principles. An intervener under the 2015 Act is a very special type of case, namely an intervener who is not an interested party, but taking part to make representations or submissions on points of law or other matters. Hence, the very specific and particular statutory framework that's now been laid down as to the award of costs for that type of intervention, which is the exceptional circumstance test. But again, it's wrong to conflate the two. We were classified as an intervener under CPR Part 19, but we're not an intervener in the same way as we would for the purposes of judicial review proceedings. Indeed, I'd suggest the Home Secretary would be an automatic interested party, if not a defendant, if this had been by way of judicial review. The second point to note is that my learned friends fail to read the judge's order with the care with which it deserves in terms of the reasoning, and have glossed over what he said. On page 52 of the core bundle, the reasons were clearly set out, identifying both a separate issue for the Home Secretary and a reason to be represented. And can I just deal with the omissions that have flowed into this? If one looks at the wording on page 52, the two things you haven't been referred to are in the second sentence. The defendant was not in a position effectively to apprise the court of both of the wider context for asylum accommodation and the background to the resumption of the use of the bell in early 2025. No, that's not even been tackled. That is a reference to the extensive parts of the evidence and the judgment dealing with the Home Secretary on the Home Office's engagement with the council before the Bell Hotel resumed, you'll see there's lengthy recitation of documents and evidence that the Home Office brought to the court about that engagement, because it was being suggested by the council that not just Somani but the Home Office had kept them in the dark about the potential resumption of the use and had not engaged properly. All of those allegations were made in evidence against the Home Secretary, and the Home Secretary called two witnesses, one dealing with the need for the asylum accommodation and another dealing with the extensive engagement and the incorrect analysis of what had happened in early 2025, which was then dealt with extensively by the court in tackling this point about the Epping having a reason to pursue an injunction when they did. Not only is that reference, but it's clearly an issue which the Home Secretary was well placed, indeed not the defendant, to deal with, because it related to factual evidence about the engagement between the council, which was the subject of our witness evidence. As we've alluded to in the skeleton, the Epping proposed to cross-examine both our witnesses. They had to be called to court to deal with that. They abandoned that at trial, and there was no cross-examination. But all of the evidence that was presented was accepted by the court and features large in the judgment, and clearly satisfies and is part of the reasoning for allowing the Secretary of State her costs of having to attend. And of course, the other matter is the reference to the judgment of the Court of Appeal at paragraphs 81 to 84. I haven't got time to take your ladyship there now, but there the Court of Appeal was flagging up the point I made earlier as to why the Secretary of State did have a separate interest to be represented at the trial, not just for the previous thing, but at trial, which of course she then duly satisfied, and the court found justified by reference to the evidence I've just talked about, and therefore rejected paragraph 25 of the Epping's submissions. And so the judge then applied the Bolton test correctly, and in my submission, that is a pure exercise of judicial discretion based on clear knowledge of what actually happened at the trial, the reliance placed on the material, and whether or not indeed it was a separate issue, which indeed it was, and which the Home Secretary could give evidence. In addition to that, the need for asylum accommodation and fulfilment of the duty is quintessentially a matter for the Home Secretary to give evidence upon and to assist the court on, and which the Epping could clearly expect to be potentially liable for costs in respect where they had not engaged with the Home Secretary at all in respect of those issues, let alone seek to reduce the issues for the court to decide. So in our submission, there is no basis for granting permission to the judge's impeccable application of the principles that apply to a second award of costs in this case. Unless I can assist further, those are my submissions.
Thank you very much, Mr. Strong. Mr. Butler.
My lady, if I might just emphasise two very short points. The first concerns ground one. The judge made an assumption in favour of the council as to whether there had been a breach of planning control. He didn't make a concrete finding on breach. The judge then made concrete findings on planning harms. And the question I pose is, how might the concrete findings on planning harms have been altered if the judge had made a concrete finding of breach? And the answer in my submission is it could have made no difference. And in those circumstances, there was a good reason for the judge not to make a concrete finding on breach, so as not to preempt the planning enforcement process. Second point, in my submission, the pressing need for asylum accommodation was plainly a relevant factor, as the Court of Appeal identified when considering the interim injunction. The question of what weight to give that factor was for the judge, with within the parameters of rationality, the weight he attached can't, in my submission, possibly be impugned as irrational. That's all I propose to add.
Mr. Butler? Thank you. Mr. Coppell?
Very short points in 4 minutes maximum. First of all, my learned friend Ms. Wigley submits that Section 187B is used where there's an apprehended breach. Well, it's not so confined. It says in terms actual or apprehended breach, and there's no hierarchy between the two. That's point one. Point two is Ms. Wigley submitted that the judge considered all of the factors that made it just and convenient to give or refuse an injunction, and the court will be aware the analysis by the judge below starts at paragraph 206, and it's divided into 3 headings. There's planning and enforcement history at 208 to 226. There's environmental harm and urgency 227 to 270. There's countervailing factors, as he terms them, at 271 to 282. And then he draws them together in his analysis at 283 to 294. And in that drawing together, he puts front and centre the decision-making process. That's at 284. And our point is that there's no consideration in the structured way required in South Bucks, and which we gave the judge in our skeleton below. It's in the supplementary bundle, tab 6, paragraphs 129 to 157, with the various considerations that felt to be taken into account, with the important starting point, which had been identified by Lord Bingham in his speech. That's tab 6 at paragraph 29. If there's a breach of planning control, then that's the starting point. There's a powerful reason for granting an injunction. And that's the structured way that the Court of Appeal and the House of Lords in South Bucks exhorted, and which we submitted to, but isn't dealt with. So that's point 2. Ms. Wigley then says, this is point 3, that Article 8's significance in South Bucks is a distinction without a difference, is the phraseology she used. It's simply not correct. And in Lord Bingham's speech, he quotes extensively from Lord Justice Simon Brown. It's paragraph 41, which is in the quotation, where Simon Brown deals with Article 8. And the reality is that Article 8 was the lodestar in those appeals. It was the lodestar in the exercise of the Section 187B discretion. And that was not the case here. And your Lordship, Ladyship, are also referred to paragraph 37 of the judgment of Lord Bingham, or the speech, sorry, of Lord Bingham in that case. Because my learned friend may think it's a distinction without a difference, but Lord Bingham certainly did not. He thought that Article 8 was front and centre important.
I've got 37. Where are you reading from?
It is in page...
I've got 119.
It is... did I say page? Sorry. Yes, 119. And you'll see there, the public authority, the English court, has prohibited Section 6.1 from acting incompatibly, including Article 8. It follows, in my opinion, that when asked to grant injunctive relief under Section 187B, court must consider whether, on the facts of the case, such relief is proportionate in the convention sense, and grant relief only if it judges to be so. So front and
but what about the next sentence?
Although domestic law...
He's saying it's no different. It's often the way with human rights.
No, but the point is that was of critical importance in that case, whether you characterised it in...
Well, that's because it was a case about Article 8.
Yeah.
Yes, and this is not a case about Article 8. That's why
I see.
why it's a distinction with a giant difference from this case. So that's the point that I make there. Finally, the judge did make, this is Mr. Butler's point, the only other point that merits response. The judge did make a concrete finding on breach, and we see that.
I thought your complaint was that he didn't. I thought the whole essence of your complaint was that he didn't make a concrete
Well,
finding on breach.
he didn't in relation to the first point, but then he did when it came to discretion. So if you look at paragraph 283 and paragraph 295, he is quite clear that this was not, as we had submitted, quote, a flagrant breach. So your Lordship asked me during the course of my earlier submissions.
All right, if there was a breach, it wasn't flagrant. Isn't that rather semantics? I mean, it seems to me that it drives a coach and horses through your primary argument if you're saying, well, he found there was a breach in one place and didn't find there was a breach in the other.
It doesn't. It accords with my argument, because my argument on the first point is that he had to reach a finding in relation to breach, including the gravity of that breach.
Right.
He didn't, he expressly didn't, but then took an opposite view when it came to discretion so far as the flagrancy of the breach was concerned. The point is that my learned friend Mr. Butler says, well, it couldn't have made any difference whatsoever because there was no concrete finding. There was a concrete finding.
Well, his submission was that there was a concrete finding on planning harms, and that the concrete finding on planning harms would not be affected depending on whether he also made a concrete finding on breach. That's the submission that Mr. Butler made that I wrote down anyway.
Correct, but it's the siloed approach, we say, to breach and just and convenient, which we say is the flaw both in his submissions and indeed in the judgment below.
Okay.
And the proof of the pudding is in your reliance upon paragraph 109 of your skeleton in the High Court, which you took us to early this morning.
Yes, and also those other paragraphs that I've just taken your ladyship and lordship to, where we say this is a structured approach, you have a starting position, here are the factors, and that's what the judge should have adhered to. Your lordship's looking puzzled.
I'm trying to interpret my handwriting.
I can help if you need the paragraph numbers again.
Well, there was if you finish that point, you right towards the beginning of your reply, you took us to Lord Bingham again in South Bucks, and I thought you said paragraph 29. It was the public interest in enforcing planning control type point.
Yes, so it's paragraph 29. The paragraph runs over the page.
Yes, indeed.
It's the foot of page 115 in the bundle up to the top of page 116, where he comes to the conclusion that if it appears that a breach or apprehended breach will continue to occur unless and until effectively restrained by the law, and that nothing short of injunction provide a restraint, that will point strongly towards the grant of an injunction.
And what the principle you get from that is what again?
Well, the principle is that if assumption here, as we say, was the case, there was a breach of planning control. The way we put it in our skeleton argument to the judge, if I could take the ladyship and lordship to that, in the supplementary bundle, at bundle page 90.
The starting point, paragraph 129.
Correct, that's the starting point.
So that was page
90 in the bundle.
Thank you.
90.
Yeah, and then 129. Thank you.
And then we've underlined the various considerations latency, 133, prospective planning application, 134, down to 140, the public interest, 141, down to 147, respecting the views of those living in the community, 148, 149, delay, no other enforcement action, and then 151, alternative sites, down to 154, paragraph 155, alternative forms of enforcement, 156, other considerations. So a structured approach that was
Yes,
exhausted.
well, I wasn't so much asking about that. I wanted just to make sure I understood which particular part of Lord Bingham you were relying
It was
upon.
that particular part.
And it's in support of the proposition that there is a public interest in the enforcement of planning control. Now, going back to what the judge did, if we look at page paragraph 206 of the judgment, where he refers to South Bucks and then refers to a summary of the principles you get from South Bucks in Ipswich. The first of which, one, the need to enforce planning control in the general interest is a relevant consideration, etc., etc. Did he not have this well in mind?
Well, he should have, my lord, because that, as a summary, is unexceptionable. But when one looks at what actually he did, and it starts at 208, it deviates from what he said should have been done.
We didn't mention that first sentence again.
Well, what we say is that had he modestly adhered to what we suggested in our skeleton argument, that was the safe course. He might have reached obviously different outcomes, but that was the structured approach. And instead, he's bundled in, for example, the business of placed importance on the internal decision making and so on and so forth. It's unstructured.
Sorry, thank you.
There's one reply point on costs, if we
Yes,
may be
of
indulged.
course. Ms. Peter, please.
Lady, just 1 minute on costs, just to address the 2 points that my own friend, the Secretary of State, described as omissions.
Yes.
Firstly, in terms of the reference to the background use of that. So, in other words, the lead up to the application of the injunction, we would say that that's a clear example of something that could be described as an interest of the Secretary of State, but it's not something that justifies separate representation. And in particular, because the Secretary of State is clearly contractually linked indirectly to Somani, they're close to Somani. There's absolutely nothing to have stopped Somani from putting in evidence on that point, from putting in, if it was necessary to do so, witness statements from Home Office witnesses in respect of that point. So there's no justification for separate representation in that regard. Secondly, as regards the learned judge's reference to the Court of Appeal decision, paragraphs 81 to 84, I would invite you to look briefly at paragraph 81 of the Court of Appeal decision in due course. The Court of Appeal at that point was placing itself prior to the evidence that was given in the final injunction, and at that point was essentially speculating as to matters which might have been raised by the Secretary of State. In the end, most of those matters were not raised by the Secretary of State, and in any event, our position is that none of those are separate issues. Rather, they're simply aspects of the issue that was covered clearly by Somani, and that is the question of whether it's just and convenient. So unless the court has any further questions, those are my points.
Yeah, that's very clear. Thank you very much. Yes. Well, can I, on behalf of the court, express our gratitude to all counsel and all the legal teams sitting behind them for their industry and the way in which they've managed to succinctly present the application and the arguments on both sides. We are well aware of the importance of this case and that there is great public interest in it. We think that the appropriate thing to do is therefore to take time to consider and digest everything that's been said to us both on paper and this morning. It would not be fair to any of the parties involved in this case to immediately tell you what our answer is going to be. So we want to take a little bit of time to consider it. We hope that it won't take too long for us to be able to give you an answer. When we do, we will hand down our judgment in a draft form, and that will be subject to the usual confidentiality provisions, but perhaps if the parties need to consult other people who need to see the draft in order to be able to take instructions, if they can kindly let either my clerk or my Lord's clerk know, so that we have a compendious list of people that we should be sending out the draft judgment to, that would be very much appreciated. Obviously, I don't need to tell anybody in this courtroom of the importance of keeping the draft confidential, but I'm afraid I do have to say it in open court because it is very important, and the consequences of a leak can be very serious. It can be treated as a contempt. Very happy to have typing corrections. I take a slightly perhaps wider view of what that entails, but it isn't an opportunity to re-argue the case, particularly on a permission application. But thank you all very much once again.
Thank you both.
All rise available.